in fair housing work, beginning in New Orleans with the Greater New Orleans Fair Housing Action Council. And Morgan will be facilitating our discussion today. He will introduce our two panelists. And Morgan, before Morgan speaks, I just want to remind us of a couple of housekeeping things. Throughout the webinar, please feel free to use the question bar to submit your questions, as well as if there's any issues that you're experiencing, please let us know. And with that, I will turn over to Morgan.
Thanks very much, Cheryl, and everyone for joining us this afternoon. We are glad to be here today with some of our partners in North Carolina at the Fair Housing Project of the Legal Aid of North Carolina. And we are glad to be joined by both advocates in North Carolina as well as from across the country. I just wanted to share a brief word on why we're talking about this particular topic at this juncture. NAFA is engaged in some fair housing advocacy work in North Carolina, and in particular in the Charlotte region. And in conjunction with some of our work there, we have been talking with various partners in the region about fair housing issues and needs. And one of the identified needs that was flagged by some of the Hopwa advocates that we were conferring with there was that a specific training on fair housing and disability discrimination for Hopwa advocates or fair housing or disability rights advocates that work with Hopwa clients would be helpful. And we are glad to have some of those partners with us here today on this webinar. We also determined that it would make sense to open up the training discussion to a broader audience base. And so we're glad to be joined here by a number of advocates from across the country. And in addressing this issue with some of our partners in North Carolina, we're glad to welcome, in particular, our two featured presenters today from the Fair Housing Justice Project of the Legal Aid of North Carolina, Kelly Clark and Lauren Brazil. Kelly has served as a supervising attorney of the Fair Housing Project of the Legal Aid of North Carolina since 2011, and from 2002 to 2011, she was a staff attorney in various offices of the Legal Aid of North Carolina, and is a graduate of Wake Forest University undergrad and the University of Arizona for a master's, and has her JD from the University of Denver College of Law, and is going to be sharing the overview on this topic with us today with Lauren Brazil, who is also a staff attorney, also at the Fair Housing Project of the Legal Aid of North Carolina. She represents victims of housing discrimination in state and federal court, as well as in administrative proceedings. She is a graduate of Lehigh University, and has her JD from Temple University School of Law. And both Lauren and Kelly will bring with them a wealth of experience on this topic that, again, for those broad panelists on the call, will be somewhat North Carolina focused, but hopefully we'll have some broad applicability for the work that everyone engages in. And with that, I think there are a couple of surveys that we wanted to draw your attention to at the start of the presentation here. I will turn it over to some of my NAFA colleagues here. I think at the start of the presentation, we wanted to poll participants to get a broad sense of folks who are with us and your sort of familiarity with fair housing rights and responsibilities, because I think there may be some broad range of participants. So we'll turn it over to my colleagues before we commence the substantive portion of the presentation to administer a couple of poll questions for your immediate feedback. So I think if you draw your attention to the presentation screen, you can actually go and select who is in the audience here. Just pick the answer that would sort of best fit you, and give us your response in short order. And I think after we administer this first poll question, there will be a second poll question, and then there will be a report on the findings. So it looks like we have 72 total attendees. I believe organizers and panelists don't vote, so please log your vote here on sort of who is attending to get a broad sense of the participants. And then Cheryl and others, if we could go to the next question. Thanks for everyone's patience with us here. I think we are looking at the cover screen and processing the results perhaps on the first question and teeing up the second question.
Thank you so much, Morgan. Can you all hear me now?
We can, yep.
So based on that first poll, it shows that 27% of the audience are attorneys, 27% are non-attorney advocates, 5% are staff at social service organizations, 35% indicate that they're nonprofit service providers, and then the remaining 5% checked other. So thank you all for voting on that. So I will do the next poll. I launched the second and last poll, which has to do with how long you've been in fair housing or how many fair housing training you've attended. So I'm going to launch that right now.
Great.
Okay, thank you again so much for participating in that poll. Based on the results, 9% indicate that this is their first fair housing training, 26% indicate that they've attended 2 to 5 fair housing trainings. 14% indicate between 5 and 10 fair housing trainings, and more than 50% indicate 10 or more fair housing trainings. So thank you all. And I'll turn it back over to Morgan.
Thank you so much, Cheryl, and thanks for everyone for responding. It does sound like there is some depth of experience, and so please, if you do, in the course of covering some of these remarks, if there's specific questions that some more nuance or detail would be helpful on, as Cheryl mentioned, there is the question feature as well as the chat feature. You can post your questions, and we'll be receiving those and filtering them through the facilitation and raising them in the course of the presentation. So please, at any point, do post a question, and we'll be processing that. But with that, I will turn it over to our presenters from the Fair Housing Project of the Legal Aid of North Carolina to cover some of this substantive material. Thank you so much, both of you, for your remarks today.
Thank you, Morgan, and thank you for NAFA for this opportunity. My name is Kelly Clark, and I'm here with my colleague, Lauren Brazil, and thank you all for participating and signing up for this presentation today. Lauren and I hope that we can, it sounds like a lot of you have had a lot of fair housing training, so we're hoping that we can add to what you already know. For those of you, if this is your first training, we hope that we can provide, along with NAFA, a basic understanding of some of the protections under the Fair Housing Act and some of the other statutes that we'll be going over, that you can be aware of in your line of work. If you're representing clients that are in the Hopwa program, we're hoping that there are, for you all, that there are some, like the title of this presentation, there's some tools that you can use in your representation or in your advocacy. So today's agenda, we're going to start off going just a brief overview of Hopwa, the Housing Opportunity with Persons with AIDS program. Then we're going to jump into a fair housing primer, going over some basic concepts. And then we'll focus then on the fair housing protection specifically for persons with for persons with disabilities, a general overview. Then we'll go over reasonable accommodations and at the various stages where you can be asking for these requests on behalf of your clients or consumers. And we'll also cover service and assistance animal. We've found in our experience a lot of questions do revolve around that particular topic, dealing with reasonable accommodations. We'll also look at how reasonable accommodations can be raised to avoid evictions and subsidy terminations. We'll talk briefly about reasonable modification requests and then best practices when asking for requesting the reasonable accommodations and reasonable modifications. And then we'll go over some other protected classes, particularly of source of income or public assistance discrimination. And then at the end, we'll have time for some questions. So, why Hopwa and fair housing is important. I mean, there's, from some of the research that Lauren and I were conducting before today's presentation, particularly in the context with AIDS and HIV, this phrase, housing is healthcare, come up. You would see it in several of the cases that we were reviewing and in articles and so forth. And primarily it's because of the great quote in this New York case dealing with disability discrimination about how people who aren't, well, this is not a great what it's saying, but just how it capsulizes it, about people who aren't housed tend to not get the medical care and they die very quickly. And this is why this is so important about the preservation for housing, particularly for people with AIDS and HIV. So for the housing opportunities for persons with AIDS, what is it? It's this program that was created, a housing program that was created in 1990 by Congress. It's for persons who have AIDS, who are HIV positive, and their families. And there are a variety. My experience has been primarily with the rental assistance and the tenant-based assistance, much like what it looks like with the tenant-based Section 8 voucher. That's been my experience, limited experience with Hopwa. But it's a variety of services, and these include, housing development, the rental assistance, which can be the tenant-based assistance that I'm talking about, as well as project-based, moderate rehabilitation of the single-room occupancy, counseling and referral services. It also can include fair housing counseling, and also supportive services. This includes short-term supportive housing, mental health counseling, substance abuse counseling, as well as transportation. So there's a variety of things that Hopwa can cover or fund. For the rental assistance, again, it can be project-based, so where the assistance stays with the building, or it could be tenant-based, so that the assistance is following the tenant into the market. For the tenant-based, it can operate much like, as I was saying before, the Housing Choice Voucher Program, and that's where you're having a particular entity that's administering the voucher. You have a tenant, and then you can have a private landlord. In that particular program, the similarities with the Housing Choice Voucher Program is that the housing must meet the housing quality standards, the HQS. Also, the housing is based on the tenant's income, and so the tenant can't be making these side payments to a landlord if the landlord is demanding more than what's been specified in the housing assistance payment contract or the HAP contract. That's prohibited. Just like it is in the Housing Choice Voucher one. Also, with Hopwa, an interesting part just to be aware of is that if the title, the household member who has the voucher passes, because this is also a program for the families of persons with AIDS and HIV, there is a reasonable grace period for the family members to be able to stay with the housing, and that's not to exceed 1 year. Also, with Hopwa, there are regulations, just like with the federal regulations, just like with the Housing Choice Voucher Program, that you can look to for guidance. And we have some of the sites here, and you'll find it at 24 CFR and the parts at 574 and the parts that are listed here. And they have to be followed. And so, one is the assistance cannot be terminated, or it can be terminated if a participant, so the person who has the Hopwa assistance, violates the program requirements or conditions of occupancy. When I went to then the site for the federal regulation, I was hoping to find, well, what are the program requirements and what are the conditions of occupancy? They're not listed there, so you'll have to look at the other documents that your clients have, with the lease or so forth, or other program documents to spell that out. But, that's how the assistance can be terminated if there are violations of that. There's also within these regulations this nugget, and it is where grantees, so those that are getting the Hopwa funding from HUD, they must ensure that supportive services are provided so that a participant's assistance is terminated only in the most severe cases. So this particular reg has two things, that obviously may catch your eye. One is about that supportive services are provided so that termination of the assistance is only in the most severe cases. And again, these supportive services include, but not are limited to, health, mental, drug and alcohol abuse treatment, and counseling. So it feels like there's a little bit more, right? That potentially how this assistance, kind of like a good cause, but even a little bit more about, in the most severe cases. There was a case out of New Jersey in 2009 that sought to make this argument that, well, a private landlord can't terminate or evict in this particular case, except for the most severe circumstances. And they were trying to say that it's more than what was being alleged at the time. And in this case, the Hopwa participant had been, the allegations towards him was that there were drugs found in his unit, 0.4 grams of marijuana, and the argument of his attorneys was saying that he should not have been evicted or should not be evicted. He should be given these support services. And it's, again, as the regulation says, it's only in the most severe cases where the termination should go forward. And the court in New Jersey, they didn't find that as persuasive. The case had some other good parts to it, which we'll get to, but they found that it wasn't this heightened standard for evicting a Hopwa participant. Not this, as the regulation says, in the most severe cases. And basically it found the finding of the drugs did constitute some of the most severe, a severe case. However, in the decision, the court also notes that someone that is receiving services or housing through Hopwa, they aren't barred from, if they are terminated, even if in this case the assistance was, from going to another Hopwa facility or another Hopwa supported housing. So it did note that in its decision. But that's one case. But again, why we're going over this overview is, in addition, we're going to be talking about reasonable accommodations. But as you know, in your line of work, there are other defenses, other things you want to be raising. And so one is whether the regulations are being followed and whether the particular circumstances involving your consumer or your client meet up with the regulation that allows for the termination of assistance. So other requirements. That in here is that there are due process requirements in terminating the assistance that have to be followed. The minimum due process requires Hopwa participants to be given written notice with a clear statement for reasons for terminating the assistance, and that's generally been construed for pre-termination, so not post-termination, but that you get this letter before your assistance is being terminated, and there's the reasons. There's a clear reasons as to what they are. It's not vague as to why the assistance is being terminated. There's an opportunity to review the notice, the termination decision, to confront opposing witnesses, present written objections, to be represented by counsel before a person that made the decision to terminate the assistance, much like what we see in some of the other HUD-funded programs. And also, minimally, what's required is a prompt written notice of the final decision. When Lauren and I were reviewing cases, Hopwa cases, and so forth, we did find this one. It's Cotton v. Alexander and Brothers of Bonaventure House, a 2003 case, and the court noted that in limited circumstances, that gives rise to what's known as an imminent threat, that can support that there be a post-deprivation hearing. So after, so the hearing after the fact. And the facts in that case where there were two tenants who their Hopwa assistance was being terminated, one under supposedly this threat of harming another tenant. The other one, it was the allegation that he had gone into another resident's room and tried to assault that person. The court, this was on a motion for summary judgment. The court found that there were these facts so that it had to go to trial on those bases. But even in those circumstances, the court was like, even in those two that I just am describing now, those two tenants, that both of those tenants were required to get a written notice for the reasons for the termination prior to them being told to leave. So the hearing might have to occur after, but not that written notice. That was to occur before. And so now I'm going to pass the rest of the presentation, well, part of it. I would like it to be rest, but no, to Lauren Brazil.
So hi, everyone. So we're going to get into...
Lauren, real quick, this is Morgan. I had neglected to mention at the outset that there will be a copy of this presentation that will be made available. That was one question that had come in, and just wanted to clarify that to folks, that this will be sent to the participants shortly. And wanted to note that at the transition. Turn it back over.
Great. Yeah, we will make this available. I know there are a lot of case citations and statutes in here that we want everyone to be able to use this PowerPoint as a resource. So we're going to go into the fair housing portion, and we're going to give a quick overview. Our presentation today is going to focus on the Federal Fair Housing Act, but we want you to keep in mind that there are also state and local fair housing laws, and then there are other federal statutes that provide fair housing protections that you can also use to advocate on behalf of your clients. Our fair housing guru, Chris Brancard, always calls it the layer cake. And so it's just something to keep in mind. So we're going to focus on the Federal Fair Housing Act today. And so broadly speaking, the Fair Housing Act applies to dwellings. It includes almost every residential rental unit or any unit that's available for the sale or rental. It includes single and family, multifamily housing, group homes, shelters, migrant housing, assisted living, long-term housing, and land where housing could be built. There are some limited exemptions under the Federal Fair Housing Act. Your state and local fair housing laws may have different exemptions. They may have additional exemptions or provide additional coverage. And again, other civil rights statutes may provide coverage. So if you are a advocate new in this area, you please, reach out to fair housing experts who can help guide the exemptions. Two of the most common exemptions that we've sort of seen are what's known, the first one is the Ms. Murphy exemption, which is an owner-occupied building with 4 or less units. One example would be a duplex where the owner lives in one unit and rents out the other unit. The sale of a single-family home without advertising or an agent is also an exemption under the Federal Fair Housing Act. But one thing to keep in mind is that even if a property is exempt from the Federal Fair Housing Act, it only applies to parts of the Fair Housing Act. So they still cannot, housing providers cannot make discriminatory statements or publish discriminatory advertising or discriminate in the financing. So it's a very nuanced area of the law. So the fair housing laws apply to rentals, both private and subsidized, sales, insurance, lending, advertising, and statements about housing. So inquiries like, can you live independently? Or have you ever been in a drug treatment program would be violations of the fair housing laws. It includes harassment based on any protected class. I think we commonly hear more about sexual harassment, but it also includes racial harassment, because of somebody's disability. It includes harassment by a housing provider. It can also include tenant-on-tenant harassment, retaliation, interference, and threats. Are all part of the Fair Housing Act protections. So the Federal Fair Housing Act has 7 protected classes. It prohibits discrimination. The first one's based on race. The second is color. It's color of your skin. Usually we think of it within a particular racial group, so a light-skinned African American or a dark-skinned Latino. National origin is another category that is protected, generally thought of your place of birth or your ancestry. It also has been interpreted both by HUD and certain courts to include language and sex and accent. In 1974, the amendments to the Fair Housing Act were done to include sex or gender. It includes nonconformity with gender stereotypes, and the HUD equal access rules are that HUD programs are open to all eligible persons, regardless of, quote, actual or perceived sexual orientation, gender identity, or marital status. Familial status is another category that is protected by the fair housing laws. It protects families with individuals under the age of 18, and it protects people who are in the process of securing custody of an individual who's under 18, and women who are pregnant. And then the final category protected by the Federal Fair Housing Act is handicap or disability, which is the term that we use, is the preferred term now. And that's what we're going to go into more detail about today. This is sort of a quick guide of what is prohibited with the corresponding statutory provisions. So refusing to rent or negotiate or sell or otherwise making housing unavailable is a broad category that can cover a variety of actions that deny somebody housing, different terms and conditions because of protected class, discriminatory statements, misrepresenting availability. Discrimination based on disability is within this 42 U.S.C. 3604F section of the law. And then finally, interference, coercion, threats, or intimidation are within 3617. So this is sort of a quick guide. There are, broadly speaking, 2 theories to prove discrimination under the Federal Fair Housing Act. The first category is intentional discrimination or discriminatory treatment. It's generally thought of treating someone differently because of his or her membership in a protected class. Usually you're looking for discriminatory intent or animus as an element that you would have to prove. It's thought of as more overt forms of discrimination. So I can't rent to someone with a mental disability. We charge an additional fee for an emotional support animal. There's an additional security deposit for an individual who uses a wheelchair. Those are all examples of intentional discrimination. Non-intentional discrimination are claims where the evidence of animus is not needed. So denying a reasonable accommodation or modification request, or unduly delaying the request, making a statement that indicates a preference or limitation, so statements like no kids, and then disparate impact or discriminatory effect. And that's when we're looking at a neutral rule that disproportionately affects a particular protected class. So criminal background screenings that disproportionately impacts African Americans and Latinos. Employment and or minimum income requirements may disproportionately impact individuals with disabilities. So disability discrimination is where we're going to focus on today, and so we're going to jump right in. So the definition of a disability: a physical and mental impairment that substantially limits one or more major life activities. It includes people who have a history of such an impairment or being perceived as having an impairment. It includes people associating or residing with people with disabilities, so family members or roommates. AIDS and HIV are disabilities under the FHA. Okay, so discrimination, different treatment because of somebody's disability is prohibited. Inquiries into the nature or existence of disability is also prohibited. Now, there is an exception in order to determine program eligibility, like in Hopwa, but you still cannot exclude for other disabilities. So just a few quick examples of violations: refusing to rent because a person has a mobility impairment, refusing to rent because someone has an emotional support animal, refusing to rent to an individual who is unable to work due to a disability and receives SSDI as income would be considered discrimination, asking a prospective tenant whether they are disabled or whether they receive SSI or SSDI, refusing to rent because an individual because a landlord suspects that an individual may have AIDS or be HIV positive would also be a violation. Accepting Section 8 vouchers, but not Hopwa vouchers, could be discriminatory treatment under the Fair Housing laws. Imposing more burdensome rental inquiry process on recipients of Hopwa vouchers. It could be both a disparate treatment claim and a disparate impact claim.
All right, so talking about now the affirmative steps under the Fair Housing Act that housing providers have to provide persons with disabilities, and that is to afford them an equal opportunity to live in the property. And these affirmative steps are reasonable accommodations, granting reasonable accommodations, granting reasonable modifications, and also following the post-1991 builder requirements. The Fair Housing Act has design and construction requirements that have to be followed, and if they're not, that's something, if they're not accessible for persons with AIDS, and there's specific guidelines about this, that also can be a violation of the Fair Housing Act. But these these affirmative steps included in the Fair Housing Act for persons, protections for persons with disabilities, this is the way that the law is leveling the playing field. And going to the next example, we'll show this. Particularly, this is actually coming from a case that Lauren had several years ago, where her client lived in a second-floor apartment and received Hopwa rental assistance voucher. His disability affected his mobility. As a result, he used a cane to assist him with walking, and he lived in a second-floor second-floor unit, and was having difficulty getting to that unit. And so one of the things that George can do here is that he can ask the landlord to move to a ground floor unit as a reasonable accommodation for his disability. His disability meaning here he has mobility limitations. The reasonable accommodation would be here the policy that probably the landlord has is first come, first serve wherever they're placed, and what they're potentially eligible for. So George is going to be asking as part of a reasonable accommodation based on his mobility impairment to be at a ground floor unit. And here, because thinking about how the Fair Housing Act and allowing for this reasonable accommodation, or allowing or including these reasonable accommodation protections, is that walk to the second floor unit for George is not the same walk as someone without the mobility impairment. And so that difference, there's that difference. So to level the playing field, George can ask for an accommodation to be moved to a ground floor unit. One of the things that does, if that's something that's being requested on George's behalf, question is, can the landlord charge George, a fee to allow the move? And no, under the guidance and of the protections afforded under the Fair Housing Act in the reasonable accommodation context, no. And that's even if the lease says that there is to be a fee to be charged. All right, so based on that example, you all, given the polling, you all know this, most of you know this, about what a reasonable accommodation is. And that is a change in the rules, the policies, or procedures. And the change is necessary because of the person's disability in order to provide the person with disability a full, equal use and enjoyment of the housing. So with George, again, the rule was, their policy or so forth, the landlord's was, we put you where first come, first serve, or where you're eligible for. He's asking for that ground floor unit, a change in that policy because of his disability. And it's necessary because you can make the connection between his disability and the need for the ground floor unit. And having the ground floor unit would provide him with that equal use and enjoyment. This is something that can be, a reasonable accommodation can be requested at any time, before tenancy, when applying, during the tenancy, and even when facing eviction, even after the eviction court papers have been filed, even if it's on appeal, the accommodation can be asked for. And it can be requested by the tenant, family member, doctor, social worker, therapist, or others. When can a reasonable accommodation request be denied? So there is, as part of the reasonable accommodation, the analysis, or when it's happening, is that invoking from other federal statutes and regulations about this interactive process that's supposed to be happening. If you put out on behalf of your consumer or your tenant request for reasonable accommodation, the landlord is supposed to be engaging, or the housing provider is supposed to be engaging in this back and forth process, assessing the need or whether the reasonable accommodation is to be granted. There are cases that support that process, and they're listed below. As well as even in that Howard case that says but C in that case, and you'll get, again, a copy of this presentation. That case, it cited to those cases that says that the Fair Housing Act, in the analysis of reasonable accommodation, there is supposed to be this interactive process. The court made this distinction that the Fair Housing Act doesn't allow for a separate claim of action for the failure to engage in the interactive process, but it does talk about that generally in the reasonable accommodation analysis, you are looking at that. So a housing provider can deny the request if the request is not reasonable because it would require, and these are the buzzwords, fundamental alteration in the nature of the services, program, or activity, or the request creates an undue financial and administrative burden. And just note here as a little star that there's also potentially another way that the accommodation could be denied, and even for a modification request, and that's if it poses a direct threat. But for instance, for an example of a fundamental alteration, let's say, and we all pretty much know about when there's a no pets policy that a housing provider has, and your client needs an emotionally support animal, and so you're asking for a change in that policy of no pets, right? And based on the client, there's a link between the client's disability and the need for an emotionally support animal. But let's say your client says, I really need this animal, but I can't, let's say it's a dog, can't walk it. Do you think the property manager can walk the dog every day for me? No, that would be an example of a fundamental alteration of the program and services. Here are some examples of reasonable accommodations that could be asked at inquiry. For instance, here, the minimum gross monthly income required for the rental. An accommodation could be, and this is from an actual case, the Geibler case out of the Ninth Circuit, 2003. It's a wonderful case to read and follow. But in this case, the tenant was working, became disabled, was unable to work, applied for disability, and then was trying to move to this apartment, but he didn't meet the income requirements of having like making three times the amount of the rent. per month, and so he looked to see about having his mom as a co-signer, and that was denied. And so as a reasonable accommodation request, it was asked because he was, as someone who was disabled and as a direct relation to his disability, wasn't able to work, and then that was of his lower income, that the accommodation of the policy of not allowing co-signers was to request that his mom be a co-signer, and he was successful eventually in court on that. This one about individual cannot rent from a family member. When Lauren and I were reviewing the Hopwa manuals across the country, we kept seeing this, and this is where there's a general rule for Hopwa about not renting from a family member or so forth, but in these manuals it talk about except though if renting from a family member is needed as a basis of a reasonable accommodation, that should be allowed. So just be aware of that. And as we already talked about, a no pets policy asking for allowing for servants or assistance animal. There's also in the reasonable accommodation request in this analysis is that it has been successfully brought in this recent wonderful case out of Virginia. Unfortunately, there was not a great case from our state of North Carolina and our federal courts, but it was asking for, as it was a criminal policy or no criminal convictions, and asking if you can make the link between the disability and the criminal conviction that resulted, that you can ask for the housing provider to as a reasonable accommodation, to not look at that conviction if you can make that link. And that was successful in the Simmons case, but that's something else to be aware of potentially that can be as another tool to be looking at in advocacy here. You follow in that type of analysis, you follow the normal reasonable accommodation procedures and requirements. This can be potentially a difficult argument to make, so you want to have really good facts. And there may be this difference between violent offenses and nonviolent. In Simmons, I believe the criminal conviction was based on indecent exposure. That was the incident there. In Evans, the criminal conviction was related to drugs, and so that your facts are going to be important. These are examples, RA examples to be made during the tenancy potentially. First come, first serve parking is the policy. Based on a mobility impairment of your client, you may be asking for, as a reasonable accommodation, as a reserved parking. Maintenance, the policy may be maintenance requests must be submitted in your writing, but if you have a client who has some cognitive disabilities or so forth, about doing that in writing, that is an accommodation of that policy. You can be asking to accept that for verbal requests. Like the example with George, 1-year lease for a 2-floor unit, moved to George signed that lease, but now because of his mobility impairment, he wants to be able to move to a first floor as a request for reasonable accommodation, or as part of the reasonable accommodation. You may have a client because of emergency hospitalization, or maybe the unit is exacerbating their disability. You may have a client who has PTSD, and maybe the noise of where they live is triggering episodes, and so they want to be able to break the lease if they found another place. And so if the lease has in there, that there has to be monies paid and fees paid for breaking the lease, you can be asking as an accommodation where fees are not to be paid, because there's the link between the disability and the need for the accommodation, which is to break the lease, because the place where the person lives is being exacerbated by the neighborhood. This case example is one following a case that Morgan had, and that he shared with us as we were preparing for today's presentation. And it was his client who was in a group home, he had AIDS, HIV. He was taking medication that gave a false positive on a drug test, and drug tests were required in the group home where he was living. And so, that was a violation of the program rules about testing positive, and so whether terminating assistance for that. And so the question was, what can John do? And one is, well, he can fight that I didn't violate your rule because this was a false positive, number one. And then number two, what John else can do is that he can request as a reasonable accommodation to the policy that because this was, a false positive from legally prescribed medication, to avoid that. Sorry. Oh boy, I hit the wrong button. Sorry. Okay, here we go. Back on track. So then of looking at assistance animals, again, just of knowing this, there are, rules for pets. Service assist animals are not pets. Under the Fair Housing Act, what's protected are what we traditionally think of as service animals under the ADA, as well as other animals known, and all of it is they're protected as assistance animals. So service are the ones that are trained for specific tasks. They don't have to be formally trained for that task. Assistance animals are any type of animal as well, or they're any type of animal, and they don't have to be trained. An emotionally support animal doesn't have to be trained to be a companion animal. Support letters can be written by, and it gives you gives you who can do that. Requests for the assistance animals, landlords can impose if the animal is an assistance animal and all the boxes are checked. They can't impose breed restrictions on assistance animal, weight restrictions, charge fees, rent, and so forth. But the owner still may require, just because the animal may not be trained, for instance, as an emotionally support animal, that doesn't mean the animal gets to run free and be aggressive and be a nuisance on the property. So there are these other responsibilities that have to be met. As Lauren talked about, you think about using the reasonable accommodation to avoid eviction, like layer cake is what we learned from Chris Brancart when he does these presentations. It's just one that you're generally adding to the defenses or the claims that you're looking at, because the denial of a reasonable accommodation request, as well as the denial of a reasonable modification, that can be raised as a defense to an eviction. If your eviction is dealing with the behavior of your client that's related to the disability, it can also be a counterclaim. And again, this can be raised at any time. Susan Silverstein makes, in her presentations, always focuses on this. Is kind of stuck with me, is that before even looking at reasonable accommodations in the eviction context, first look to the lease and the tenant's behavior. Did the tenant actually violate the lease or breach the lease? And the lease says that they can be evicted for it. All right. If so, did the housing provider comply with all the notice requirements? Of certain due process protections applied? Did the housing provider comply with that? Then look at whether there's a reasonable accommodation that could eliminate or minimize the risk of the behavior of happening again. And so then below are some examples of when you can, or examples of how reasonable accommodations or modifications can be raised in these types of common alleged breaches of the lease. These are some great examples about how raising reasonable accommodations to avoid evictions. Lauren has cited there the cases. A lot of this comes from Fred Fuchs, his wonderful guide on defending evictions or defending families and individuals against evictions in the federally subsidized programs. You can find it online. It was just updated in 2015, but on pages 36, I think, through 39, in the footnotes there, it's a great summary of how reasonable accommodations are brought in defense to evictions, as well as here on the second page too. And let me see here. All right, and yeah, okay. And now for reasonable modifications. You can tell who is not the most equipped to do. I should not be in charge of the mouse here. But anyway, for reasonable modifications, like reasonable accommodations, you're looking at a change. But for modifications, you're asking for a change in the actual physical premises. And again, it has to be related to the disability. And to do so is to give that person the ability to fully use and enjoy the dwelling. This includes the common areas and the interior of the unit. For reasonable modifications, there may be a request to return the interior of the unit to the original condition upon the end of the residency, and based on that, then these reasonable escrow requirements are okay generally in the lease. However, if the modification is purely aesthetic, then there should not be, and the case law supports this, there should not be the need to return it or to the original condition or to pay escrow. An example of this, I had a client who asked for the vinyl to replace the carpet in the living room because of her disability, her chemical sensitivity, and so forth. Because the vinyl did not change the re-rentability of the unit, she wasn't required to change the unit to have carpet put back in after she left. Who pays for the modification? In private, it's generally going to be the tenant. And this includes when you have Section 8 vouchers, tenant-based vouchers, or low-income housing tax credit. But if your client or consumer is using their voucher like at a Section 8 project-based or rural development, or if they're in public housing, it will be for modifications. If they're reasonable, it will be the housing provider's responsibility to pay, and that's based on Section 504 of the Rehabilitation Act. Here are some examples of modifications that most of you already know. And now we are switching back over to Lauren.
So we just want to go over, what makes a complete reasonable accommodation or modification request. Sometimes a client will come to you and it turns out that they may have already made the request to the housing provider and just not realize that it's actually an accommodation request under the Fair Housing Act. And so one thing to keep in mind is that there aren't any specific magic words that somebody needs to use to ask for an accommodation, so long as they are making out the elements that they have a disability and that they need this change either to the physical premises or to this rule because of their disability. A RA/RM request can be made orally or it can be made in writing, and there's no specific forms that somebody needs to use or to complete. However, there are some best practices that we would recommend, and we include a checklist in here to hopefully help advocates that are helping people make these RA/RM requests to put them together. So best practice is to make it in writing. If you can confirm receipt or get confirmation that they have received and acknowledge the RA/RM request, that's even better. Your request should explicitly state that you're requesting a reasonable accommodation or modification under the Fair Housing Act. And so then depending on the disability and the requested accommodation or modification, there are two documents that you may need to submit. The first is the request letter asking for the accommodation or modification, and then the second document is a disability verification letter. If a disability is an obvious disability, then you don't generally need to have this verification letter. So, for example, if somebody has a mobility impairment and they use a wheelchair and they need a reserved parking space outside the front door of their unit, a disability verification letter would usually not be required. If somebody uses a wheelchair and because they have a mobility impairment and they need an emotional support animal, you may need a verification letter to provide that link between the disability and the need for the emotional support animal. And so here's just a quick checklist that you can have and again, you'll have a copy of this, but if it's being written on behalf of an advocate, you really want to explain your relationship to the person with the disability who needs the reasonable accommodation. And you want to just state that the person has a disability. Now, you want to focus on the substantial limitations of their major life activities, so how their disability affects their ability to see, walking, lifting, reaching, hearing. You don't have to disclose the specific disability or the diagnosis, but you want to focus on the limitations that are affected, and then you're stating that you need this specific accommodation, and then explain why that accommodation is necessary and related to the disability. You want to ask for a response by a certain date. Landlords and property managers must respond within a reasonable or prompt time is actually the word that the regulations use, and the failure to promptly respond can be construed as a denial. A verification letter is usually written by a medical professional, but depending on the need, it can be written by a social worker or a therapist. And this is just an example that you can, again, have for reference. The individual is explaining their relationship, how long they've cared for this individual, that they are familiar with their medical history, and that due to the disability, they have limitations, and you want to expressly state them, and then to alleviate those difficulties, they need this change, or they are prescribing an assistance animal that will allow them to cope with their disability. So there are certain things that a housing provider can request when evaluating an accommodation or modification request. One is this proof of disability that can come in the form of the disability verification letter. Again, only if the disability is not obvious or otherwise known. The housing provider is not entitled to medical history or even a specific diagnosis. It's tying the disability to how the accommodation or the change will assist that person to be able to live in their housing. So there are a few, some more exceptions to the fair housing laws. So if an individual would pose a direct threat to the health or safety of others or cause substantial property damage, then a landlord is not required to rent to the person unless an accommodation could eliminate that threat. Now, this determination must be made on an individualized assessment. It cannot be made because of a housing provider's fears or speculation or stereotypes. It is about that particular individual, and again, it's unless a reasonable accommodation could eliminate that threat, then the housing provider should allow them to reside there. Current use of illegal drugs is excluded from the definition of a disability and would not be protected. So we wanted to talk a little bit about some other protected classes. So far we've really focused on the Federal Fair Housing Act. Some states and local fair housing laws have additional protected classes. Some states will explicitly protect sexual orientation, gender identity, gender expression, source of income, recipient of public assistance, age, veteran status, marital status. Now, some of these categories may also be covered under the interpretations of the federal fair housing laws or under HUD policies like the Equal Access Rule, but they're not explicitly protected under the Federal Fair Housing Act. And so source of income and individuals or families who receive public assistance are not explicitly protected under the federal or the North Carolina Fair Housing Acts. But there are many states and local fair housing laws that have established source of income or a related category as a protected class. Now, the definition of source of income depends on the jurisdiction. Some jurisdictions have specifically added vouchers and other forms of public assistance to their local fair housing laws, in part to deal with court decisions that have found that source of income does not mean vouchers. And others have explicitly excluded vouchers from the definition of source of income. So it really depends on the jurisdiction. And PRAC has a great resource that was updated in June of 2018 that covers all the local jurisdictions across the country that are protecting source of income and the related categories and the different definitions. In these jurisdictions, plaintiffs have brought successful claims against housing providers who refuse to rent to individuals because they are a voucher recipient. So in the Cruz case, it was an individual plaintiff as well as testing where the housing provider refused to accept HASA vouchers, which is the program in New York. In the LaFrac case, again, different policies were used for voucher recipients. They raised both disparate treatment and disparate impact claims, both source of income and disability discrimination. The Marcano case, they accepted Section 8 vouchers but did not accept HASA vouchers. So again, you're looking at disability discrimination as well as source of income discrimination. In states like North Carolina, and where source of income is not explicitly a protected class, there is one other little nugget, and that is low-income housing tax credit properties cannot discriminate against applicants or tenants because they receive a Section 8 voucher, a Hopwa voucher, or another form of public assistance. And so the federal citations are there, and for North Carolina advocates, The Housing Finance Agency, who administers the North Carolina Low-Income Housing Tax Credit Program, has what's called a tenant selection plan. And I know other states have a similar type of plan. And in there, it explicitly states that the housing providers must affirm that they will not deny applicants because they are a voucher recipient. So, source of income, disability discrimination, and reasonable accommodations. Is there an opportunity there? And so an individual with a disability who is unable to work and relies on SSDI and a voucher to pay their rent may request that a landlord accept a voucher as an accommodation to their disability. However, in a state where source of income is not protected, if the landlord refuses, then whether that individual can prevail in court is unclear under the Federal Fair Housing Act. Some cases have been successful, but others have not. And what we're seeing some movement in the law, but so it really depends on the jurisdiction. If the landlord already participates in the voucher program, then it is more likely to be successful, but it's not necessarily so. So it really does depend on your local jurisdiction. I think there is an opportunity to ask for the reasonable accommodation. If the landlord is already participating in the program, then it's more likely to be accepted. But how it plays out in court is a little unclear at this moment. And so what can you do? You can contact NAFA or the Fair Housing Project for fair housing assistance. You can file an administrative complaint with the U.S. Department of Housing and Urban Development or your local fair housing FAP. Or you can file directly in court. There is a 1-year statute of limitations from the last date of the discrimination to file a HUD complaint, and then 2 years to file in court. If you do file with HUD, it does toll or stop the running of the statute of limitations. And Morgan, I think, is going to kick off our ongoing HUD discussions.
Thank you. This is Morgan. I was just going to briefly note that there is, of course, some really great guidance that HUD and DOJ in particular have issued in the joint statements on reasonable accommodations and modifications, and more recently in regards to a guidance memo that HUD issued in April of 2013 on reasonable accommodations and assistance animals. That guidance, and in particular, some components of the April 2013 guidance are under review by HUD. There is some concern among folks in the housing industry about, in particular, online verification providers and the perception that the reasonable accommodation request process, especially as it relates to assistance animals, is somehow being misused. And there's been some direct advocacy that they've engaged in to HUD on this issue. And we understand that HUD is looking at questions associated with these online verification providers, questions associated with breed restrictions, of which the current guidance says that you can't institute, breed restrictions, and in regards to exotic animals, as they would say, or a non-traditional assistance animals. So this is an issue that is of concern to disability rights and fair housing advocates. And there's a broad consortium of national and local disability and fair housing rights advocates that are engaging in advocacy with HUD to ensure that they're taking account of perspectives in the advocacy community on these issues and don't unduly limit people's rights in this space. And so some of those efforts are ongoing. There was a sign-on letter that was prepared and delivered to HUD in May, asking for a meeting and noting frustration about their inability to engage HUD on this, despite their willingness to meet with industry advocates on the questions. And we're working with other national disability rights partners to kind of raise the profile of those requests and ensure that ongoing communications with HUD account for our interest in dealing with them directly on some of these questions. So that's the update on. That's the update. There's a question here that's been posed regarding any idea on when new HUD guidance on emotional support animals will come out. Well, the short answer to that is no. I mean, we understood this spring when we were trying to engage with HUD on this question without great success that they were conferring with industry folks and thinking about this with an eye to potentially getting something out during Fair Housing Month. But with HUD, when they say something like that, it can ultimately mean Fair Housing Month the next year. So it's not clear is one question there that was raised. So at this stage, we can open it up more broadly to questions from folks. And if you look at your menu bar, there again is a question tab, and you can submit your questions via the question tab, and we'll process them and bounce them off of our guests and substantive presenters, Kelly and Lauren. And I don't know, Kelly and Lauren, if there's anything else that you wanted to say kind of in closing in the course of kind of receiving questions and otherwise kind of wrapping up the substantive portion.
Morgan, I just wanted to add one thing, and this is related to with reasonable accommodations that are brought up to avoid eviction. And when you get the PowerPoint, you'll see the list of cases. But I just wanted to highlight, and many of you all may already know it, but it was the Paris v. Pappas case, the Federal District Court case out of Connecticut in 2012. And just to highlight, this is a case fighting an eviction, but also there were, as any of these cases, when you're fighting eviction, you're also looking at potential monetary damages. And so it's not only potentially keeping your client in based on the reasonable accommodation, but also for the denial of the accommodation and what potentially, compensatory damages. There may even be punitive damages awarded. But as part of compensatory damages, it's emotional distress. For me, starting out learning more about fair housing several years ago, I thought maybe how my state, under the state torts of negligent infliction of emotional distress or intentional infliction of emotional distress, might analyze emotional distress, and I thought it might be similar to in fair housing, and it's not. And so reading and you'll see it's on slide 35 when you get the PowerPoint, but the Paris v. Pappas case in the site there, that's where, even though it's in the Second Circuit, the court does a wonderful job explaining the different types of compensatory damages with emotional distress, the different ranges for garden variety emotional distress, which your client can talk about at trial or before. Not having seen a medical provider, the range can be between $30,000 to $120,000, as cited in the Second Circuit. We know that also HUD really likes this case as well. We have gotten this emails in our region about how this is a case that HUD looks to. And this was a case where someone was being evicted. She needed a live-in aid, housing provider, the landlord knew it. She was renting a mobile home lot. She had bought a mobile home from the housing provider, and she was complaining about the septic issues. And she's, complained to the housing provider. She, complained to the consumer protection group that was around, as well as the city and county. And in retaliation, the landlord said, you can't have this live-in aid. You're in violation of the lease, and we're going to evict you. When she raised the reasonable accommodation to have the live-in aid, which she desperately needed, they tried to leverage the need for the live-in aid to say, well, we'll let's have the live-in aid if you then become responsible for all the septic issues. So anyway, it's a really good case and is an example of, in addition to fighting in maybe an eviction or a subsidy termination, there's also this issue about damages that need to be reviewed with your client and to be part of the discussion and in the analysis of the case. So that's all I got on that part.
That sounds good. We do have a number of questions that have come in. So this is great, and thank you guys for submitting questions. There's a few questions here, and I'll raise these with you, Kelly and Lauren, but also have some thoughts sort of directly on them as well. So we'll chime in as well. But to kick it off here, there's a question here dealing with insurance companies and breed restrictions, and it specifically says it could be a financial burden if insurance companies bar restricted breed, right?
I don't agree.
Say that again. Sorry.
Oh, sorry, I got too excited. I don't agree. No, I don't agree.
Okay, good. Yeah. Okay. Well, let's hear it. I have some strong opinions on the matter as well. Why don't you elaborate and then I'll chime in.
Okay. We've heard this before, and actually, when we were given a presentation to housing providers, so to landlords on this issue about emotionally support animals, and remember, it has to be an undue financial and administrative burden for the reasonable accommodation not to be granted. And a housing provider popped up and was like, look, if I have a client who's asking for emotional support animal, but that animal is a pit bull and my policy doesn't cover it, I can easily find another policy to change to. So I'm getting some inside scoop from the housing providers. It's like, that isn't a big change. But even if it is some financial burden, again, the standard is an undue. So the housing provider is going to have to show that it's an undue financial burden to change policies or for some reason, and to an administrative burden. And I believe there is one case we can get you the site, because this is actually coming up on a current case that we have, where it was a case that basically said you can't pass on the burden with the insurance onto the tenant asking for their reasonable accommodation. That's all I have, Morgan. Waiting to hear your strong opinion.
That's great. My strong opinion is in line with that. There is, I should say, a June 2006 HUD FHEO Regional Director's Memo from Brian Green on this question, on the subject of insurance policy restrictions as a defense for refusal to make a reasonable accommodation, dealing specifically with breed restrictions. You can just Google it, Brian Green, Insurance Breed Restrictions HUD. And it's just a one-page memo, which actually does say that it's possible for such a policy restriction to pose an undue financial and administrative burden if there is evidence to substantiate the housing provider's claim regarding the potential loss, and by verifying, such a claim with, the insurance company directly, and considering whether comparable insurance without the restriction is available in the market. I actually, that's a one-page memo that was issued in 2006. I don't entirely agree with that analysis and think that there would be liability that would flow, both to the insurance company as well as the housing provider in carrying out such a discriminatory denial, that I don't think that analysis stands. I don't know the law substantively on the question, haven't looked at it specifically, but that would be my sense. So in line, but with reference to that memo. Great. So
yes.
Let's do another question here. I think there's another question that deals with actually insurance, but in the context of reasonable modification, and that is just a direct question. Can landlords require liability insurance for reasonable modifications?
So our answer would be no, and there's a HUD reasonable accommodation memo, joint statement, HUD DOJ joint statement that I believe goes into that question, but no. Generally speaking, a landlord cannot require liability insurance for a reasonable modification.
However, there is, I think provision in that reasonable modification joint statement about funds for repair in escrow.
Yes, and that is.
And that is something that a tenant can be made required to pay.
As long as the modification isn't aesthetic, though. That's the limitation on that. So it's like with my case, it was the client that was changing the living room from carpet to vinyl. And under the case law about, well, if the change or the modification is purely aesthetic and it's not going to change the re-rentability of the unit, then the tenant's not required, to rechange it or to return it back to its original condition. But for instance, if you're lowering the sink or lowering the counters, and that is going to change the re-rentability, then that can be the difference with that.
Perfect. There's another question here. So the question is, the PowerPoint stated that a family member can make a reasonable accommodation request on behalf of a tenant. But the question is, does the family member have to live with the tenant or be a power of attorney or a healthcare power of attorney for the tenant in order to do this?
I would say generally no. You do need the tenant's consent, and if you are an advocate writing it on behalf of an individual, you might want to explain what your relationship is to that individual with a disability when you're laying out why the person needs the accommodation. You'll want to review the accommodation request letter that you're submitting with the individual with a disability, and as long as you have their consent, the person does not have to reside with them or be officially a power of an attorney.
Great. So this is another question here that deals specifically with secondhand smoking cases in smoking complexes. This is actually one that I haven't dealt with directly and don't have a keen sense of. I'm curious. So I'll just read it out. Do you know of any secondhand smoke cases, and specifically where the client asked for a reasonable accommodation to move to another unit, and the housing provider referred the request to their legal counsel, who responded that it's a smoking complex? And that they don't have to move the client, as the problem will still be in the complex, which is policy that allows for smoking.
I think we've seen, and I haven't looked at this issue as much, but haven't had a case come through. But when I think I was reviewing some things, I saw several cases out of California, which I guess would not be a surprise. But about this, where it's come to us is where people were trying to, with our clients that are smoking, trying to say, is there any way that you would raise a reasonable accommodation that your client be allowed to smoke and that. So we saw it on the other end. This one being about the tenant who's asking to move from the secondhand smoke and how it's maybe exacerbating or with the health condition that they already have. Again, I think I've seen cases out of California. We can review those and send them along with the PowerPoint if we see any that are supportive of that. As well as I think you walk through the same analysis that you do with with any reasonable accommodation. So if the landlord or housing provider is saying we can't move you because we're a smoking complex, we would be looking at and I believe the link would be there between the disability and the need to move and the secondhand smoke. Is it really an undue financial and administrative burden? Is it that there is a unit where the tenant could move to where the person next door isn't smoking, or on either side? So you would be doing that same analysis, and not just taking, well, no, we can't do it because it's we're a smoking building. Be like, well, okay, if you're a smoking building, but are there any that are not smoking? Any of the units that are not, that are the residents that are in there? Could I be moved here? That's what I would think. But if they can show that it would be an undue financial administrative burden, then like with any of the analysis, I believe that's where it would end.
Well, there is a potential, although not usually ideal. You could ask for an early lease termination without having to pay a penalty, and the person could try to find housing elsewhere because the secondhand smoke is exacerbating a disability. So it's an alternative to, you can't move them elsewhere, but then we need to, then that individual may just need to leave the property. I also think HUD-funded properties are moving to non-smoking, so I assume the question is in the private housing market. Not sure if you have any other thoughts, Morgan.
No. I think that there is some prevalence in some jurisdictions where there's legalized marijuana and medical marijuana of issues around sort of dueling requests for kind of a non-smoking environment, and then a sort of specific disability-based request to accommodate smoking. And under current sort of federal laws, I think it's a difficult context in which to forward a reasonable accommodation request on behalf of someone who's putting forward medical marijuana requests in some under existing kind of law and regulation. But that's a changing landscape, and a little tangential to the direct question that you guys, I think, did a good square answer to. There's another question here about 811 vouchers, which I am not significantly familiar with. But the question is specifically whether an RA to allow an 811 voucher as one would allow a third-party payer, and whether there are cases to address this. I'm not sure if you guys are otherwise directly familiar with 811 supportive housing vouchers.
And what you mean for instance, I'm just asking as a follow-up, I'm asking, does somebody else pay the rent as a third-party payer, or what's for a recipient of an 811 voucher, or what can the person asking the question help us a little bit more? Just because I don't have I want to make sure I'm understanding the question, and that's just my ignorance, not the person asking the question. I'm trying to make sure I get the third-party payer. Is that someone that's paying the rent on behalf of someone?
Sorry.
Yeah. So
I think that's,
it's a question of somebody who has a city voucher, so the 811 voucher, who wants it to be accepted by the landlord. So the city would be paying, obviously through the 811 program. So, but you can't mandate someone participate in the Section 8 program. So can you make a reasonable accommodation request for an individual landlord that they accept a 811 voucher, and if they fail to accept it, then are they in violation of the act, or are they going to make an argument that you can't force them to participate in the Section 8 program, even if it's Section 811?
Well, I guess one I would be looking at in answering this question, I would be looking at what jurisdiction am I in and whether there is a source of income protection, which isn't in the Federal Fair Housing Act. I'm just saying, but look at that. So that's the easy answer, right? But then the other is, and what Lauren, was sharing, and it does get confusing. But in some of those cases where there was the jurisdiction of source of income, so it was the plaintiff was raising, you got to accept this HASA voucher. It's violation of the New York, human rights law where their source of income protected. But it was also a claim under the Federal Fair Housing Act, the disparate impact and disparate treatment. That was also raised as an argument. And, if you don't have source of income protection and you're trying to argue about the acceptance of the 811 voucher and making it so, you would be, there is some case law about talking about if you can link, like in the Giebler case, or the Geibler case, which is cited, you can make the link of your client is disabled, they're not working. Were they working, they would be able to rent where this landlord is. So you make that link between the disability and the need for the voucher, right? And then if you find out that the landlord accepted other vouchers, but not maybe the 811, then maybe you have a disparate treatment claim under the Fair Housing Act, because most 811 vouchers are going to be dealing with folks with disabilities. Then maybe if you have looking at the statistics of a straight up regular voucher. So maybe if you have those fact scenarios going on, or if the landlord had in the past maybe accepted or currently the 811 voucher, but is it now? Maybe. So it's not a great answer, but so maybe depending on the facts. I definitely think it's one to talk with fair housing advocates about, and email and with the client's consent if you have some more questions about that. Does anybody else, Lauren or Morgan?
No, I think it's going to depend on your jurisdiction and potentially disparate impact claim for disability discrimination, like in LaFrac, but it's going to be fact specific. So disability discrimination under the Fair Housing Act is what Lauren's meaning. So you have, if you're in a jurisdiction with source of income, you have that protection, but then potentially maybe, depending on the facts, it could be disability discrimination based under the Federal Fair Housing Act, or your state, if you have substantially equivalent on some of the theories we talked about, the disparate treatment or the disparate impact, depending on the facts.
Great. Well, thank you all for these questions. It seems as if we've mostly addressed the questions that have been raised. Let's see, there's a couple more coming in. So there's a question about modifications, and this can be maybe just the last question for our time here. There's a question here about modification in public housing. So the question is here, can you give any examples of court cases in which federally financed landlord was required to pay for structural modifications under the Rehab Act? So that would be, Section 504 of the Rehabilitation Act, or otherwise under the Fair Housing Act, I would add.
So offhand, I cannot think of a specific court case. I believe there is something, again, in that HUD-DOJ joint statement about this, and I believe they cite the cases in there.
And that's a joint statement. There's a HUD-DOJ joint statement on accommodations, and those, you'll see a cite for that at the end of the presentation. There's also a HUD and DOJ joint statement on modifications. And what Lauren is talking about is that in the modifications, joint statement on modifications, there's some authority. Now, we just don't know, but we'll look about, whether there's cases cited in it, but it's definitely cited in the joint statement on modifications that if Section 504 applies, which it would in the public housing context, then it's the housing provider's responsibility to pay for it as long as it's not an undue financial and administrative burden. So you can cite to that joint statement on modifications for that support for that.
Great. There was another memo on, I want to say, accommodation in the public housing context that a federal or a national civil rights organization, a National Housing Law Project, I think, links to it online. That may have some information on this. I'll check that out and make sure we include that in whatever we send along. Great. Well, just wanted to wrap things up here by thanking you all for joining us. In particular, thanking Kelly and Lauren for their thorough remarks and Yeoman's effort of sort of providing information that could be sort of digested by the 9% of you who this is sort of brand new to, as well as the broader group of you who are versed in this. And thank you for your questions. Thank you to NAFA colleagues Cheryl and Caesar and Siobhan in processing your questions. And we look forward to continue to work with all you guys, and especially those of you in North Carolina who had specific interest in this. Thank you for your partnership.